Good morning to everyone joining us from all across the Asia-Pacific region, and welcome to FinneGAN's webcast, the USPTO's 2019 Patent Eligibility Guidance, 2 months in, Sea Change or Business Methods as Usual. I'm Gary Ma, Managing Partner of FinneGAN's Taipei, Taiwan office, and I'll be your moderator today. It's my pleasure to welcome our presenters, Adriana Berge and John Mulcahy. Adriana leads FinneGAN's Patent Office Practice section. She not only worked in the startup, biotech, and pharmaceutical industries as an analytical chemist, but also has over 15 years of experience as a patent attorney. Ms. Berge counsels clients on all aspects of their patent portfolio domestically and internationally. She focuses on opinion work, counseling work, patent prosecution and management, and post-grant proceedings in the U.S. Patent and Trademark Office. She brings a unique perspective by blending her legal, technical, and industry experience to the table. John has more than 20 years of experience in all phases of patent law. His practice focuses on patent prosecution and post-grant proceedings in the USPTO, client counseling, and litigation before federal district courts and the U.S. International Trade Commission. John is a former primary examiner at the USPTO and has broad knowledge of patent prosecution matters and manages the prosecution of patent portfolios for clients from Fortune 100 companies to small startups. Before I turn things over to our presenters, I invite everyone to participate by submitting questions. Just click on the red Q&A button at the lower center of the webcast interface and type your question into the Q&A window, then click Submit. We will get to as many questions as we can during the question and answer session, which will take place at the conclusion of the presentation. You may enlarge the slide window at any time by clicking on the green Enlarge Window button on the top right side of the slide window. The slides will advance automatically throughout the event. If you are experiencing any technical difficulties, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. And now, I'll turn it over to Adriana and John to begin our presentation, the USPTO's 2019 Patent Eligibility Guidance, 2 months in, Sea Change or Business Methods as Usual.
Thank you, Gary. Welcome, and thank you for joining us on this webinar. We have a jam-packed agenda in this rapidly evolving area of subject matter eligibility. We will first discuss the 2019 Revised Patent Eligibility Guidance. Next, we'll discuss some frequently asked questions and go over some of the new USPTO examples 37 to 42. Then we'll round out our discussion by examining some rejections and responses. And finally, we'll take a look at how the PTAB has been addressing the 2019 Revised Guidance. Just as a programming note, we've included a lot of slides, and likely some we will not be able to go over given the allotted time. But we're providing them for your reference and for your convenience. With that, I will turn it over to John to start the discussion by examining the 2019 Revised Patent Eligibility Guidance itself. John?
Thanks, Adriana. So on January 7th of this year, the USPTO issued their revised patent eligibility guidance, and it was effective the same day as it was published in the Federal Register. Now, we're all familiar with the Alice-Mayo test, a 3-part test for determining subject matter eligibility. Under Step 1 of the Alice-Mayo test, you ask whether the claim falls within a statutory category. That is, whether the claim is directed to a process, machine, manufacturer, or composition of matter. Under Step 2A, you ask whether the claim is directed to a judicial exception, such as a law of nature, a natural phenomena, or abstract idea. Under Step 2B, you ask, even if this claim is directed to a judicial exception, does the claim recite significantly more than this judicial exception, such that there is an inventive concept that removes the claim from the realm of abstract ideas and places it into the realm of patent-eligible subject matter? So it's a simple 3-part test, but as we've seen in the past few years since Alice, the devil is in the details. In particular, Step 2A of the ALICE test requires examiners to determine whether the claim concept is similar to concepts that were previously identified as abstract by the Supreme Court or the Federal Circuit. And this is something that examiners are just not equipped to do. Since ALICE, there have been more than 70 case decisions from the Federal Circuit and the Supreme Court where dealing with subject matter eligibility. And so what Step 2A was asking examiners to do was to compare the claims of each application to the claims of these prior decisions and then decide whether or not the claims were similar enough that they should be rejected as being ineligible abstract ideas. But that simply wasn't practical. Examiners have a limited amount of time in which to examine an application, and they haven't got the training really to compare claims to claims. And so what they ended up doing was not looking at the claims of these prior cases, but really looking at a short, oftentimes one-sentence summary of those cases, and looking at the claims of the application and saying, well, does this one-sentence summary describe these claims? And those one-sentence summaries tended to bring in a lot of claims and be applicable to a lot more claims than they really should have been applied to given the actual case law. And so what's happened in the 2019 patent eligibility guidance is that the office has finally admitted that this regime, the ALICE construct, where you have to compare the claims of this application to these 70 prior cases, had just become impractical. There's too many cases for examiners to apply, and so we're getting inconsistent results between different sections of the office. And so in an effort to improve consistency and predictability, the office issued this new guidance in January. And so what the new guidance does, in essence, is it breaks Step 2A of the ALICE test into two prongs. In prong one, we ask, does the claim recite an abstract idea? And we'll see in a minute that we're not looking at these 70 cases anymore. We're looking at a very finite list of what is considered to be abstract. And then under prong two, assuming that the claim does recite an abstract idea, we ask, does the claim recite additional elements that integrate this abstract idea, this judicial exception, into a practical application? If the answer to that is yes, the claim is patent eligible, and we can move on from 101 and consider 102 and 103 issues. If the answer under prong two is no, there is no practical application recited, we still go to Step 2B of the ALICE test and ask, is there something significantly more recited in the claims? So I mentioned under prong one, there is a limited, a finite list of ideas that are considered abstract under the new guidance. And these are mathematical concepts, relationships, formulas, etc., methods of organizing human activity, in particular fundamental economic principles or practices, and then also mental processes. And here we include concepts that are capable of being performed in the human mind. Whether or not there is a generic processor recited to perform these functions, if they are capable of being performed in the human mind, they are considered to be mental processes under the guidance. Now, under Step 2A, prong two, asking whether this abstract idea is integrated into a practical application, what they're asking here is whether the claim applies, relies on, or uses this abstract idea in a manner that imposes a meaningful limit on the judicial exception. And what they're looking for is for the claim to be more than a mere drafting effort designed to monopolize the judicial exception. So if the claim is found to be integrated into a practical application, the answer under prong two is yes, and the claim is patent eligible. And we'll go into some examples later on and kind of flesh out the details of what it means to be a practical application. But one of the important important points under prong 2. Under the previous guidance, we often had examiners looking at your claim, taking out what they consider to be abstract, looking at the elements that were left, and then deciding that those elements didn't save the claim because they were just well understood, routine, and conventional. But under the new guidance, the office emphasizes that under step 2A, prong 2, you must give weight to all the additional elements, whether or not they are considered to be well understood, routine, and conventional. You need to consider whether or not they provide a practical application, even if that practical application is, for all intents and purposes, old and obvious. And so that's an important point, an important distinction. We'll go in, as I said, to the examples later on and kind of flesh out what that means in a practical application by the office. And so under the new guidance, we have a 4-part test that the office hopes is simpler for examiners to apply than the old 3-part test. So asking these 4 questions. Does it fall within a statutory category? Does it recite a judicial exception? If so, is it integrated into a practical application? And even if not, does it provide an inventive concept? And so those are the 4 questions we'll discuss in relation to some of the examples later on. With that, I'll turn it back over to Adriana.
Thanks, John. So after looking through and going through the guidance, I bet there's some questions out there. So why don't we take a look at some frequently asked questions? I think one of the first questions that I had, at least to begin with, was, when is this effective and is there a comment period? And it turns out that, as John mentioned earlier on, once this published on January 7th, 2019, it became effective. And we are about to wrap up the comment period on Friday, March 8th. And it's interesting to note, I took a look at, who has submitted comments so far on this new guidance, and it turns out there's a whole host of individuals. I didn't see any corporations, I didn't see any law firms, and it really has been a lot of individuals posting comments on these revised guidance. Now, I think the next question that we often got when we took a look at the revised guidance is, how are they going to train the examiners? The Patent Office has over 8,500 examiners, and how are they going to get them all on the same page? And I think with any complex, rapidly evolving areas of law, the USPTO often gives supplemental training to its examiners. This is to ensure everybody's essentially trying to be on the same page, to the extent that 8,500 examiners can be on the same page. The USPTO has conducted additional training on the guidance, continues to update its materials reflective of the current and evolving case law. And right here on the slide at the bottom, where we have some training materials and we have some hyperlinks, those are to the USPTO presentations that they gave to the examiners. I believe the first PowerPoint presentation, it's almost 200 slides. So you can take a look and see how the examiners have been trained and what type of examples and how, the Patent Office is telling their examiners to look at a 101 rejection, how you form that 101 rejection. What do you look at from a claim perspective? We also have fielded a lot of questions as to whether the guidance changes the subject matter eligibility framework itself, and it does not. Quite frankly, the Patent Office can't do something like that. They're an administrative agency that administers the law, where the legislative branch makes the laws and the judicial branch evaluates it. So no, that framework has not changed at all. And what we've put here at the bottom of the slide is a chart to updated materials that the Patent Office has said they're going to maintain and keep updated. And in particular, with a red arrow, we're pointing to this chart. They have this great chart that identifies all the current cases and whether those claims have been eligible or ineligible. And as you can see here on the slide, it was recently updated in the beginning of February. I anticipate they'll do another another update in the beginning of March, but it's a great resource and it's a great practice tip to go there, take a look at that chart, and see if you can make some analogies to the claims that you're currently prosecuting, to essentially say, look, courts have already said this is eligible subject matter, and look, it's very similar to what I'm prosecuting right now. What if, I think the other question that we also got was, what if I already have an outstanding office action and it's a 101 rejection under the old guidance? What should I do? And here, I think this is just a great opportunity from the applicant's perspective to really set the tone for how you want your claim subject matter analyzed under this new guidance. You get the first crack at the apple, so to speak, and you get to set the tone. What we have on this slide is really how the examiner is going to take after looking at, after issuing that office action, how they're going to look at your response and how they're going to proceed. And really, I think the biggest bullet point here to pay attention to is the last one, where it says if the claim remains ineligible under the new guidance, the rejection can be made final if the basic thrust of that rejection is the same. So under this new rubric, so to speak, step 2A, prongs 1 and prong 2, if that same rationale is still applicable as was under step 2A and step 2B, well, they can make that office action final and they don't have to give you a non-final. Whereas if it changes, they should be giving you a non-final office action. And then finally, we probably have some cases that are currently on appeal that were evaluated or prosecuted under the old guidance. Well, what do? And I think here, the best bet is to take a look, see how the claim would fare under the new guidance. Each technology center has discretion, and depending where you are in that appeal process, for example, maybe you're waiting for an examiner's answer. And you may find that in the examiner's answer, the examiner takes a look at those claims under the new guidance. Maybe there's a new ground of rejection. Now, if you have an outstanding reply brief, again, maybe this is a great opportunity to take a look and sprinkle in some discussion, or maybe a good portion of the discussion under in your reply brief under the new guidance. I think it's worth considering. I think it's worth taking a look. And to the extent, maybe this is a good time to even call the examiner if you're on appeal and talk to him about or her about the issues, the new guidance, how the claims would fare under the new guidance. I think I'm just a big proponent of calling examiners, having discussions with them to really get to the root of the problem and see if there's any room for compromise. So next up, we're going to take a look at the new examples that have been issued by the USPTO, examples 37 to 42. So I'm going to turn it back over to John. John?
Yep, thanks. And I would just echo Adriana's comment. This is a great opportunity to contact the examiner and try to set a new tone under the new guidance and try to get your cases allowed. A lot of the examiners are very receptive now. The message from the office and all of their training has been, we want fewer 101 rejections. So examiners are being encouraged, not to make these rejections. In the past, I think examiners were afraid not to make a 101 rejection because they would be overlooked, or they would have their SPE and the 101 specialist in their technology center looking over their shoulder and saying, well, why didn't you make a 101 rejection here? But now the opposite is true. The SPEs and the 101 specialists are looking over their shoulder and saying, you probably don't need to make a 101 rejection here. And so this is a great opportunity to kind of step in and take better control of where prosecution is going in a lot of these areas that have been impacted by a 101. And one of the best tools that we have in this early part of the trajectory of this new guidance is these examples 37 to 42. So the same day that the USPTO published the new guidance, they published these new examples 37 to 42 with about 10 sample claims and showing examiners and practitioners, how these claims would ideally be treated by an examiner under the new guidance. And so we'll go over a few of these examples. And so just a few notes about these slides. So here we see examples 37 through 42, and here we see the claims. So for example, example 37 has 3 claims, 38 and 39 only have 1 claim each, 40 and 42 have 2 claims each, etc. I find it more instructive to take these claims out of order. And so in these slides, I've rearranged the claims as follows, as shown on this slide. And the reason for this is, like, for example, 37, Claim 3 in the example is actually kind of the base claim, the claim that you would have submitted first during prosecution. Claim 1 is an amendment of Claim 3, and then Claim 2 is an amendment of Claim 1. And so I find it more instructive to kind of go through the claims in this order. A couple other things you'll notice from these examples. The PTO wasn't very creative when they were going through these examples. Every claim in these examples is a method claim. And every claim, and this is not really surprising because most claims do pass step 1 of the ALICE test. They are directed to a machine, process, apparatus, or composition of matter. One of the other things you'll notice with these examples, though, is step 2B is not going to help you under these examples. If you don't pass through at least prong 2 of step 2A, wherein your claim is directed to a practical application, your claim is not going to have that something significantly more that's going to save you in step 2B. And so those are some common themes that we'll see throughout these examples. And in the interest of time, I'm only going to go over a couple of these examples. I'm going to start with example 37, claim 3. So in claim 3, we have a method of ranking icons in a computer system comprising this determining step and then a ranking step. And so under step 1 of the ALICE test, we ask whether it falls in a statutory category, and here the answer is yes, it recites a process. Under step 2A, we ask whether the claim is directed to a judicial exception. And here, the answer that they give under prong 1, whether the claim recites a judicial exception, is yes. So here we have a method performed by a processor, but the steps of the method, determining the amount of use of an icon over a predetermined period of time, and then ranking the icons are things that could be done mentally. So you could look and determine the amount of use of an icon over a period of time based on unspecified criteria, and then rank the icons. And so therefore, this claim, according to the office, encompasses a mental process. Under prong 2 of the claim, prong 2 of the new guidance, so we ask whether this claim integrates this judicial exception, this abstract idea, into a practical application. And here, the office says under prong 2, the answer is no. Here we have a generic processor performing these mental process steps, essentially, and therefore there is no integration. And that's a common theme that we'll see with respect to these claims, is that the mere recitation of a generic processor is not going to save the claim from being directed to an abstract idea. In this case, the final answer from the office is that this claim is directed to an abstract idea. And then we go on to step 2B. We ask whether the recitation of the claim provide an inventive concept. But as I hinted at earlier, under these examples, step 2B is not going to save you. And so here again we have this the sole additional element is just this generic processor, and that is not going to provide an inventive concept. Same as under the old guidance, really. And so therefore the final answer with respect to claim 3 of example 37 is the claim is ineligible. Here we have the sample rejection. I think, Adriana, you were going to talk about this.
Sure. Yeah. So, same thing with the examples. The Patent Office, gave us some new examples to take a look. Well, they also gave us a sample rejection, and this sample rejection is with respect to example 37 and claim 3. And so you can take a look at what you should be anticipating or what you should be seeing from the examiner's point of view, what a rejection under the new guidance would look like. And here we have, essentially the rubric of what you should be seeing in your office action. Typically, they identify what claim, under what statutory provision the claim is rejected under, and here we have, the claim invention is directed to an abstract idea without significantly more. Then you go through, and in this excerpt from the sample rejection, you get to see that analysis. So that first paragraph, we're taking a look at step 2A, prong 1. Here it talks about, is this a judicial exception? Yes, it is. It's a claim limitation that's directed to mental processing, and it's part of that grouping of abstract ideas. The next paragraph, step 2A, now we're looking at prong 2. Has it been integrated into a practical application? And here it says, well, no, it hasn't, because there's only one additional element using the processor, and it's at this high level of generality. And next up in the third paragraph, you're going to see that step 2B analysis. The claim does not include anything else that adds significantly more than the judicial exception itself. And so we'll take a look at a little later on some sample office actions that we pulled in cases where they are evaluated under the new guidance, and you can see how this sample rejection gets modified, based on the examiner. And again, you have to keep in mind, these 101 rejections are really going to run the gamut, where you're going to have some where the examiner really articulates and gives you a full rationale, whereas in others you may only get a paragraph or two. And so, again, a little later on we'll take a look at some sample ones to see that variation and how it actually plays out in an application. So I'll turn it back over to John.
Yeah, so here we'll move on to Claim 1 of Example 37. As I mentioned, Claim 1 is really an amendment of Claim 3. So here you've added a recitation directed to a method for rearranging icons on a graphical user interface of a computer system. And now we have this step where we're receiving a user selection via the GUI to organize the icons based on particular criteria. And then the final step, automatically moving the most used icons to a position on the GUI closest to the start icon. And so here we go back again to prong 1 and ask whether this recites judicial exception. And here again, the office answer is yes. But for the recitation that this is done by a processor, the claim would encompass a mental calculation. But moving on to prong 2, we asking whether or not this claim now integrates this abstract idea into a practical application. Here now, the office answers yes. So we have now a combination of elements that recite a particular manner of automatically displaying icons based on usage, and this is providing a particular improvement over the prior art, and therefore the claim is not directed to a judicial exception, but is instead integrating this practical application, and now the claim is patent eligible at prong 2. And so this is very encouraging for practitioners, because in a lot of cases, we would have seen this claim being rejected under the prior guidance. So if the office come out here in the examples and say, well, now this claim should be considered to be patent eligible, and move on to consideration under 102 and 103, this is very encouraging. So because we're patent eligible at prong 2, we don't even have to go through step 2B. Moving on now to Claim 37, Example 37, Claim 2, we have a further amendment of Claim 1 of Example 37. So here we are adding in the determining step. The determining is done using a processor that tracks how much memory has been allocated to each application associated with each icon. And here, looking at step 2A, prong 1, asking whether this claim recites judicial exception, here now the office says the answer is no. There's no judicial exception recited because this determining step, as amended, cannot be practically applied in the human mind. And so what the office says here is that tracking how much memory has been allocated to each application associated with icons on a GUI is something that can't practically be done in the human mind. And they don't go into this much detail, but one of the things I've thought about is, well, if you really wanted to measure the amount of memory, you'd have to use some technology somewhere. You'd have to go into a computer program or get out some other test equipment to look at the memory and see how much is being used. And so it's not something that you could see and evaluate on your own. And so that may be one rationale as to why this can no longer be done in the human mind, and now we're patent eligible at step 2A, prong 1. And of course, since we're patent eligible at step 2A, prong 1, we no longer we don't have to go through prong 2 or step 2B. And so I'm going to go through here and skip over examples 38 and 39 and move directly to example 40, claim 2. Example 40, claim 2 is drawn to a method for monitoring traffic data through a network appliance. And so we have a collecting step where we're collecting traffic data, and then we have a comparing step where we're comparing the collected traffic data to a predefined threshold. And looking here under prong 1, asking whether this recites judicial exception, here the office says the answer is yes. The collecting step is just collecting data, and that is something that is kind of a pre-solution activity. And then the comparing step, comparing one number to another number is something that can be done in the human mind. And just because you recite that the steps are being performed by a network appliance, that doesn't save the claim from being an abstract idea. It still encompasses a mental process. Turning to prong 2, asking whether this abstract idea is integrated into a practical application. Here the office says that the answer is no. The collecting step, as I mentioned, is just generic data gathering. In the office lingo, insignificant extra solution activity. And just merely automating this by a generic network appliance, again, does not save the claim. And therefore, this claim is directed to an abstract idea and therefore ineligible. Because the answer under step 2A is that the claim is ineligible, we do move on to step 2B and ask whether the claim provides an inventive concept. But here again, the additional elements recited in the claims are just directed to a generic network appliance and cannot provide an inventive concept, and therefore the claim is finally held to be ineligible. Moving on to example 40, claim 1. Here we have an amendment to claim 2, and we're talking about now it's a method for adaptive monitoring network traffic, and we have the same collecting and comparing steps, but now if the comparing step determines that the traffic data is greater than a predetermined threshold, we collect additional traffic data comprising net flow protocol data. Looking now at, again, at prong 1, does this recite judicial exception? Here again, the answer is yes. We have what could be mental steps. We're just collecting data, and we only have a generic network appliance to do that. Therefore, it's still directed to a mental process and still reciting an abstract idea. But now moving on to prong 2, asking whether this claim is now integrated into a practical application, the office says that the answer now is yes. So although each collecting step may be viewed individually as mere pre- or post-solution activity, the claim as a whole is directed to an improvement in collecting traffic data. And this is a very interesting and helpful claim for practitioners who are trying to patent claims performed by a generic computer. So if your improvement is just in the software, this is the example that you would point to, because here we have a generic computer collecting data, doing a comparison, and if the comparison goes a certain way, you collect more data. So it's you collect data, if X, then you collect more data. And so it's all in the software, and yet even though that's the case, here it's integrated into a practical application and patent eligible at prong 2. And so this is a very helpful claim or example to show examiners in these areas where you're trying to patent software that is done by a generic computer. And again here, because the claim is eligible at step 2A, we don't have to go into step 2B. I'm going to skip over example 41 and move on to example 42, claim 2. This is the example that is most on the business method side of things. They don't have a good example for a financial or fintech invention, but here we have a method where we are storing information about a patient's condition, and then you're providing access to users so that anyone can update the information, and then you're storing that updated information. Under prong 1, asking whether this recites judicial exception, here the answer is yes. The office says that the claim as a whole is just reciting a method for organizing human interaction. These are just, kind of mental steps or record keeping that would have been done with pencil and paper in the past. And just because you recite that a content server is doing it now is not enough to save the claim. It's still directed to a method of organizing human interactions and not anything that needs to be done by a computer. Under prong 2, we're asking whether this abstract idea is integrated into a practical application, and here the office answers no. Here we just have a generic content server and storage devices, and these are just used as tools to perform an existing medical records update process. And simply implementing an abstract idea on a generic computer is not a practical application of that abstract idea. Under step 2B, asking whether it provides an inventive concept, here again the answer is no. Even looking at the claim as a whole, we just have generic computer components, and it's not enough to provide an inventive concept. The claim is therefore finally held to be ineligible. But here's where things get interesting. In claim 1 of example 42, the claim is amended as shown. We're talking about storing information in a standardized format. In step C, you're converting a non-standardized format to a standardized format. You're automatically generating messages, and you're transmitting messages to users on the system. Now, under prong 1, this claim, according to the office, still recites a method for organizing human activity. So even though you add all these things, it's still directed to this abstract idea. It still recites an abstract idea. But looking at prong 2, whether this abstract idea is now integrated into a practical application, here the office says yes. And this is very interesting because what the office is saying is that these additional elements that are recited in the claims provide a particular improvement over the prior art by allowing remote users to share information in real time in a standardized format. And so this claim is very interesting to me because each one of these recitations that they're pointing to in the guidance and the examples is well understood, routine, and conventional by any measure. So we have information stored in a standardized format, and then it's converted to a non-standardized format. We're providing remote access to a storage device for a number of users of our network. All these things are old and obvious. They're routine, well understood, and conventional, however you want to slice it. But even though all those things are true, here under prong 2, they can still integrate this abstract idea into a practical application. It's not new technology, but it is a practical application, and that's enough to get you over 101 hurdle, and then you can go on and talk about, okay, well, is this new software added to old hardware? Is that new? Is it non-obvious? And so at least we can get over the 101 hurdle and move on to the other things that we need to worry about and seeking patent protection for this idea. And so with that, I will turn it over to Adriana to talk about how examiners are actually treating this going forward.
Thanks, John. So yes, let's go ahead and let's take a look at some real applications and see how this is all being applied. So what's been happening from the office perspective and from the applicant's perspective? To try to get a big picture view, we conducted some searches to see how often the office, as well as the applicant, cites to this new 2019 guidance in office actions and responses. So we searched on the term listed below the 2019 revised patent eligibility guidance, and we did this on March 1st, just to get a rough idea and to get a glimpse of the numbers and the technology centers where the guidance is most active or most prevalent. So here you see in this chart what we found. So we have technology centers on the left-hand side, the number of office actions in the middle, where the 2019 guidance has been cited, and then responses from applicants, and again, where the guidance has been cited. Now, look, this is not an exhaustive and search that was conducted, but what we tried to do is get a representative look to see at the activity. I think we have to bear in mind, the guidance went into effect on January 7th, but realistically, by the time an examiner or an applicant actually intertwined that guidance into an office action or response, it was probably a couple weeks later, especially given examiners had to go through training on the new guidance themselves. But what we see is that there's certain technology centers where really it's pretty active, and that is in 3600, which is directed to transportation, electronic commerce, construction, agriculture, licensing, and review. And then on the applicant side, 2100, it looks like there's been a whole heck of a lot of responses that have been filed, again, citing the guidance, and 2100 is computer architecture, software, and information security. We also tried to figure out if we could see if the office has identified any claims that did not fall within the enumerated groupings of the abstract ideas. So early on, John went through and gave us, I think, essentially 3 buckets of abstract ideas that the office enumerated for us. And in the new guidance, they also said, well, there may be some abstract ideas that don't necessarily fall in those 3 buckets. And although it still sounds like an abstract idea, but it doesn't fit in one of those buckets. And if it doesn't fit in one of those buckets, they call that a tentative abstract idea. And in order for an examiner to make a 101 rejection under a tentative abstract idea, the examiner actually has to go to a supervisor and the technology group director to get permission to do so. So we wanted to see, well, has the office issued any office actions deeming subject matter as being a tentative abstract idea? And it looks like the office has not done so. But what we did find was that applicants were actually self-identifying subject matter into this category. category. And so here what we put together and what we summarized is, in those responses filed by applicants, how are they using the tentative abstract idea? And what we found was a lot of the responses actually were using tentative abstract idea, but they were using it just to explain the new guidance. And so they were just walking through the guidance themselves. Next up, we found some responses where they were saying, the applicant was saying, look, this is not an abstract idea, and it doesn't fall within under that tentative abstract idea either. It just, we stop at prong one. It does not fall within abstract idea. And then finally, we found responses where, the applicant was arguing under step 2A, prong 2, that even if this was a tentative abstract idea, it was integrated into a practical application. And next up, we have some sample rejection and responses that were received here at the firm itself. And I think, John, did you want to talk about this one?
Yeah, certainly. So what I did was I looked at all the office action responses the office actions we received in the 5-week period ending this past Sunday. So it started 2 weeks after the guidance was actually issued, and that kind of gave time for the examiners to get trained and start implementing the new guidance. And I compared that to a 5-week period in October, November, just to see what percent of office actions that we received had a one-on-one rejection. And one of the interesting things I found was that we as far as the one-on-one rejections go, we got about 18% of non-final office actions had a one-on-one rejection under the new guidance versus in a 5-week period we got 22% back in October under the old guidance. So about a 20% difference there. But in final actions is the big difference. So under the old guidance we were getting 30% of office actions had a one-on-one rejection under a final rejection under one-on-one. Under the new guidance, only 13.5% of the final rejections had a one-on-one rejection in them. And so that's a big difference, examiners not making one-on-one rejections final. And we've had some feedback from examiners where they've said they like to get those one-on-one rejections on the record in the non-final office action, but they're perfectly willing to withdraw them on the next office action in light of applicants' arguments. And this is proof positive of that. And so overall, again, just a limited sample size, but overall we're getting only about 2/3 of the one-on-one rejections we were getting under the old guidance. So that is, very heartening for applicants. And maybe it's not, maybe there's still too many one-on-one rejections out there, but at least the trend is going in the right direction.
All right, so let's pivot a little bit and let's figure out, now that we have this revised guidance, how do we use it? How can we come back and how do we respond to those rejections? And, here's some just sample considerations to think about, but I think they're worth going through. I think one of the first things that you should be thinking about is attacking, the office's rationale under prongs 1 and 2. Prong 1, does this recite a judicial exception? Prong 2, and I think this is where you can get the most ground, is, it's integrated into a practical application. Look at what the examiner is saying. How do they rationalize it? How do they come to the conclusion that it's not? And that's a great opportunity, a great place to start your argument. As I know, I already kind of let the cat out of the bag, so to speak, earlier on about examiner interviews, but I'm a huge proponent of conducting an examiner interview, regardless of whether it's a 101 rejection or not. Really talking to the examiner and finding out where and what the problem is really key to addressing those issues. And in some instances, although we looked at some sample rejections, we looked at what the rubric is that the examiner is, how the examiner is looking at a 101 rejection. Sometimes that just, the real issue doesn't get down on in the office action itself. And so, just picking up the phone, calling and talking to the examiner, you can make great headway. As John was going through the new examples 37 to 42, I still think it's a great opportunity to use those examples. And that office has a whole host of examples, and look at, analogize to claims that have already been identified as containing eligible subject matter. It does not change. So any claim considered patent eligible under the old guidance should still be considered patent eligible under this guidance. And again, I think arguing that integration into a practical application, that step 2A, prong 2, is really key to moving your subject matter from ineligible to eligible. Again, take a look at step 2B. I would much rather address any arguments earlier on in the analysis and not get to step 2B. But again, you may have to get to step 2B to show that significantly more. And I think in the end, you also have to consider, look, there's no one-size-fits-all. It's highly fact-specific. There's no general way that fits all types of claims and subject matter into one rubric. You have over 8,000 examiners to consider and how they develop their 101 rejection. And so again, it's highly fact-specific. Look at the facts. Look at the claims that you're prosecuting. Maybe you need to do an amendment. But really, there isn't necessarily a single rubric to take a look at to say, okay, you can use this every time for every rejection. I just don't think that it's out there. So this slide here merely highlights under step 2A, prong 2, that integration aspect. Here are some examples where it was found that the exception was integrated into a practical application. And these were highlighted in the 2019 guidance, and they really show that you're taking it that step further. You may have that exception, you may have that abstract idea, but now you take that abstract idea and you apply it and you use it. So for example, improvement to other technology or technical fields. So that second bullet point, an example there is an immunization step that integrates that abstract idea into a specific process of immunization that lowers the risk that an immunized patient will develop chronic immune-mediated diseases. Again, you're taking that extra step. You're integrating it, you're applying it, you're putting it to some useful use. And again, taking a look at this list, it really shows that you're taking that exception and you're moving it forward. You're transforming. And I think, again, these are great examples to cite in your arguments to show that you have overcome that hurdle. You have shown it's integrated into a practical application. This next slide are just some examples where there was found to be no practical implication. And again, step 2A, prong 2. And I would just remind you that, when the examiner takes a look at this and does this analysis, they have to look at the combination of elements. And it's just not a single element by itself. Now, a single element by itself may win the day, but there are also instances where you really have to take a look. The invention is really the combination of these specific elements together. The other thing that the examiner has to keep in mind is they have to consider the claim as a whole to determine that integration. And so I think those are good reminders to consider and opportunities to argue over the 101 rejection. And what we have in these next several slides merely illustrate the different ways examiners are utilizing the guidance in the 101 rejection. Again, there's over 8,000 examiners. You're going to have all these different flavors of rejections. But we wanted to present some of them to you. Now, we're not going to go over all of them because we're running short on time, but it just gives you an idea from the different technology centers really how the examiners are going to be applying them. And this particular example here in Tech Center 1600, what we see is we have the examiner citing to the 2019 revised patent subject matter eligibility guidance, walking through step 1, yes. Step 2, it's a two-part analysis. And then here, while it may be a little difficult to read on the screen here, but the examiner is going through that step 2A, prong 1 and prong 2 analysis. And then finally comes to step 2B and says, look, there's not significantly more I'm maintaining my rejection, and the rejection of claims 30 to 37 still stand under 101. Here's an office action from Tech Center 1700. Again, you see the examiner citing to the guidance, the examiner's walking through the analysis, step 2A, prong 1, prong 2. There's no integration into a practical application, and then goes on to step 2B. This 101 rejection, however, is a ray of hope, so to speak. Here, the examiner goes on record and provided clarifying comments on, the reasons why they were withdrawing the 101 rejection. I mean, hooray here. This is great. Although the limitations still recite an abstract idea, the limitations include additional elements that reflect an improvement to a technology field. Withdrawing the 101 rejection. I'm going to just skip through to this last Tech Center 3600 example, where we see that here the examiner in this case essentially does a claim chart for prong 1 and goes through and walks through the analysis under prong 1. Then the examiner takes a look here in this slide at prong 2 under step 2A and finds that the claim does not integrate into a practical application the abstract idea. And step 2B, again, these are the different flavors that you're going to see when you see your office actions, when you see a 101 rejection, and they're going to be slightly different. John, do you want to take us through the PTAB examples?
Certainly. So we also took a look at what the PTAB has been doing with the 2019 PEG, and there have been a number of decisions that explicitly mention the new guidance. And unfortunately, for those of you who are trying to patent fintech or business methods, the PTAB has consistently came out against those types of claims even after the new guidance. Now, one thing to caveat this with is that all these claims were written before the new guidance, and so they weren't drawn to overcoming 101, using the tools that we now have, examples 37 to 42, et cetera. So, going forward with those tools, we're hopeful that even with these fintech applications, we can get claims past examiners and then also past the PTAB if necessary. There are a couple of claims that were found eligible by the PTAB under the new guidance, but those are more drawn to the technology side that really they probably shouldn't have been rejected even under the old guidance. There's been one case that I found so far where the PTAB addressed the new guidance in an IPR, and basically what was happening there was that they had a hearing scheduled for a week after the new guidance came out. They asked the parties whether they want to reschedule the hearing. The parties said no. Our position is hold on, whether the old guidance, the new guidance is applied, and so the PTAB kept the hearing as scheduled, but they allowed the parties extra pages to brief the issues and extra time to argue the issues at the hearing.
Some final thoughts, and maybe some things to keep in mind as we go through and as we start using the new guidance. And these quotes here that we have on the slide really come from, they're quoted from the guidance itself, and I think it's helpful and instructive to go through them. It's important to keep in mind that the guidance it does not have the effect of rule of law. This does not constitute substantive rulemaking, so it's not the force of law. And next, this is really just a tool to help internal USPTO management to get through, and I think Director Iancu really recognized that examiners were struggling and maybe were making some questionable calls about 101, and I think that Director Iancu as well heard a lot from stakeholders that they were getting inconsistent and unpredictable results going through prosecution and having so many 101 rejections. Here the guidance really reiterates the rejections will continue to be based on substantive law. Again, this harkens back to the, I think it was earlier in our slide deck where we pointed out the USPTO maintains a chart of decisions on subject matter eligibility. It's those court decisions that the USPTO has to maintain by. And again, all USPTO personnel are expected to follow the guidance. However, if they don't follow the guidance, it's not a means for an appeal or a petition just in and of itself. And I think next up is please bear in mind that we're about to approach the end of the comment period on Friday, March 8th. They may go back, the USPTO may go back in and further make revisions to the guidelines itself. This is really an iterative process. And all along, the Patent Office has been going back and forth and helping and trying to give examiners tools in which to examine the applications under 101. So there may be further changes that are going to be made. And, I think these last two bullet points are really, really hit home. Just because you follow the 2019 PEG guidance does not guarantee that the claims are patent eligible. So you go through prosecution, you get through prosecution, and you think you've got a valid patent. That does not insulate it from further attack or from a 101 challenge or a petition at the PTAB. And again, we haven't seen whether federal courts will agree with this guidance. So there are still a lot of unknowns out here. And again, it's an iterative process. We may continue with periodic supplements as we go down this path. And again, when you look at the context in which the guidance came out, the director really saw a need to come and to add a little bit more predictability, consistency to the examination under 101. I'll turn it back over to Gary. Great.
Adriana and John, thank you very much for your presentations. This would usually be the time or point in the presentation where we would have some question and answer, but we are actually out of time today for that portion of our webinar. But nevertheless, if you submit questions, we will definitely try to get back to you and answer them offline. If you want to participate in the question and answer and submit some questions, just click on the Q&A button and type your question into the Q&A window and then click submit. And one of us will try to get back to you by email to address your question. I also want to take this opportunity to remind all of you to take a moment to complete our brief evaluation survey because we continually try to improve our programs. We would appreciate your input, which will guide us in planning future programs. Thank you all for attending today's webcast, the USPTO's 2019 Patent Eligibility Guidance, 2 months in, sea change or business methods as usual. This presentation will be available on demand in the next week. Please look for an email from us with the access link. And this concludes today's FinneGAN webcast. Thank you all for participating.